Welcome for today's session on orals. So today I have decided to use a different approach to this oral examination systems because I realized you could be wasting a lot of time, and these are on your feet situation. So this will be an audio stroke video session when I arrive at the JSC questions. But to begin with, I'm starting with an audio statement where I have a list of questions together with me. And these questions will be read with speed and answered with speed so that you capture whatever the examiner expects you to have known within the 5 minutes timeline. So I'll begin with the facets on the civil litigation because there is a high probability that the questions in orals will test on various procedures and principles and tests that usually confuse students. So we'll begin with the civil litigation. So what documents are filed to institute a civil suit in the High Court? So you can file a plaint or an originating summons or a petition. Okay, and the plaint will be accompanied by a verifying affidavit, list and bundle of documents, witness statements, list of witnesses, etc. The institution of suit anchor is pursuant to Section 19 of the Civil Procedure Act. Second question, what is the purpose of a demand letter? The demand letter is to formally notify the debtor or wrongdoer of a claim and lay down the relief being demanded and invite settlement and create a paper trail relevant to cost, interest, and pre-action conduct. It can also help notice. It can also help prove notice and sometimes support mitigation. Distinguish between a summons and a notice of summons. Summons is used to enter appearance. This is where the court process server serves you with a plaint or other enabling documents upon the defendants to enter appearance within the prescribed time. And then notice of motion, a notice of summon, generally is a notification about summons, often used where rules and practice require notice rather than personal service, or to alert a party of pending summons or proceedings. Okay, what is a memorandum of appearance? The defendant's formal notice to the court that they intend to participate or defend in the suit, filed after service of summons and before or alongside the defense. What is an originating summons? An originating process used to commence certain matters suitable for summary determination on affidavit evidence, often where facts are relatively undisputed or the issue is contraction or interpretation. The court may convert it into a plaintiff-driven suit if it becomes contentious. This is pursuant to Order 37, Rule 19 of the Civil Procedure Rules. Then, what is a representative suit? This is a suit where one or more persons sue or defend on behalf of many with the same interest to avoid multiplicity of suits. What is res judicata? This is a bar that prevents litigation of a matter finally determined by a competent court between the same parties or parties claiming under them on the same issues. This is pursuant to Section 7 of the Civil Procedure Act. What is sub judice? This is a rule that prevents a court from proceeding with a suit where the matter in issue is directly and substantially in issue in a previously instituted suit between the same parties or parties litigating under the same title pending before a competent court. This pursuant to Section 6 of the Civil Procedure Act. Okay. Limitation of actions. What is the limitation period for an action in tort? This is 3 years from the date the cause of action accrued. This is pursuant to Section 4(2) of the Limitations of Actions Act. What is the limitation period for a contract action? This is 6 years from the date the cause of action accrued, pursuant to Section 4(1) of the Limitation of Actions Act. Okay. What are pleadings? These are the formal written statements of each party's case, where we have the plaint, defense, reply to defense, counterclaim, etc., defining various issues for a trial. What is a plaint? These are the claimant's or plaintiff's primary pleading that initiates an ordinary civil suit, setting out parties, material facts, causes of action, and remedies being sought. Distinguish between a counterclaim and a set-off. A set-off. This is a defendant's claim. A defendant's claim used to reduce or extinguish the plaintiff's monetary claim, typically connected to mutual debts. Counterclaim, on the other hand, is a cross-suit by the defendant against the plaintiff or with added parties seeking affirmative relief beyond merely reducing the plaintiff's case. What is a third-party notice? A notice issued by a defendant to bring a third party into the suit for contribution, indemnity, or related relief, so the dispute is resolved in one proceeding. What is the purpose of a third-party proceeding? This is used to determine within the same suit whether the third party is liable to the defendant for indemnity, contribution, or any connected relief, avoiding separate litigation and inconsistent findings. Distinguish between striking out a pleading and dismissing a suit. Striking out a pleading involves this is the removal of a defective pleading, for instance where it is scandalous, frivolous, or results to an abuse, or it is there is no reasonable cause of action from the same, which may or may not end the suit depending on what is struck out. On the other hand, in dismissing a suit, this terminates the suit, usually on merits or for procedural default, producing a final disposal unless set aside or appealed. What is the purpose of an affidavit of service? This is to prove service, who was served, when, where, how, and by whom, enabling the court to proceed, including for default processes. This is pursuant to Order 10 or Rule 2 of the Civil Procedure. What is substituted service? A court-authorized method of service other than personal service, e.g. advertisement, email, where allowed, or affixing, etc., used where personal service is impracticable, despite reasonable efforts. What is a chamber summons? This is a form of application used for certain interlocutory steps under the civil procedure rules. Many applications are now by notice of motion, but chamber summons still appears in some procedures. What is a notice of motion? This is the common formal application method seeking court orders, supported where necessary by affidavits and grounds. Distinguish between a notice of motion and a chamber summons. The difference is mainly procedural and formal and historical usage, and what the rules prescribe for that particular relief. Substantively, both are vehicles for interlocutory relief. You follow what the specific rule requires. What is an ex parte injunction? It is a temporary injunction granted without hearing the other side, usually to prevent imminent harm pending an inter partes hearing. What are the three conditions for granting a temporary injunction? This is where we apply the GL test, that the same is to be applied sequentially. The prima facie case with probability of success, irreparable harm not adequately compensable by damages, if in doubt, balance of convenience. Distinguish between an interlocutory order and a final order. An interlocutory order is made during proceedings to preserve rights, manage the case, or give interim relief, and not a final determination of the suit. And then the final order conclusively determines the suit and is embodied in the final judgment of decree. What is security for cost? It is an order requiring a party, often the plaintiff, to deposit or provide security to cover the opponent's cost if the claim fails, commonly where there is risk of non-recovery. This is recognized under Order 26 of the CPR. What is an interpleader proceeding? This is a procedure where a neutral holder of property or money, being the stakeholder, facing rival claims, asks the court to decide who is entitled, therefore protecting the stakeholder from double liability. This is recognized under Order 34 of the CPR. What is the purpose of a pre-trial conference? Pre-trial conference is to case management, is to confirm pleadings that pleadings have closed, compliance with the disclosures, identify the issues, consider ADR, set timelines, and fix the matter for hearing efficiently. What are interrogatories in the context of a discovery? These are written questions served by one party on another to obtain admissions or clarifications on material facts, answered on oath or affirmation as required by the rules. Judgment. Distinguish between summary judgment and default judgment. Default judgment. This is entered because the defendant fails to enter appearance or fails to file a defense, pursuant to Order 10, Rule 4 of the CPR. Summary judgment, on the other hand, is entered because the defendant has no bona fide triable issue or defense. allowing judgment without a full trial procedure under the CPR regime. Distinguish between a judgment and a decree. Judgment is the court's reasoned decision on the issues. On the other hand, the decree is the formal extracted order that follows the judgment and is capable of execution. What is a consent judgment? This is a judgment entered by the court on the parties' recorded agreement or compromise with the same effect as a judgment after contest, subject to limited grounds for setting aside. We go to the appeals part. What is the role of an amicus curiae in civil litigation? This is a friend of the court who assists the court with neutral legal submissions and technical expertise on issues of public importance or complexity. He is not a party and does not control the litigation. What is the limited period to file an appeal from the High Court to the Court of Appeal? In ordinary civil appeals, the critical immediate step is lodging a notice of appeal within 14 days of the decision. Okay. What is a notice of appeal? This is a formal notice lodged in the Court of Appeal process indicating intention to appeal. It anchors jurisdiction and triggers subsequent steps where we have the record of appeal, service, etc. What is an application for stay of execution? This is an application seeking to suspend enforcement of a decree or order pending appeal or pending determination of an application to prevent the appeal being rendered nugatory. That was the first session when it comes to the civil litigation prediction questions that you'll be asked in your oral. So therefore, we jump straight to the JSC questions that featured prominently in the recently concluded interviews. So to begin with, we'll begin with the last questions going upwards, and we'll be ignoring the questions tied to the judiciary performance angle because we are targeting the Kenya School of Law boundaries. I will read question 504. What is the role? Okay, what is the role of the Attorney General in extradition proceedings versus the role of the DPP? That is a potential question. Extradition proceedings. In Kenya, the Attorney General's role is mainly executive and diplomatic. This is where he is involved in transmission of requests and receiving the same. While the DPP's role is prosecutorial and court-facing. I mean by this I mean that the issue, this is the issue, the authority to proceed. So that is a clear distinction between the two. The AG is merely diplomatic to receive and transmit requests, while the DPP is prosecutorial. It is the issuing authority to proceed and conduct the committal and extradition proceedings. So the Supreme Court has settled that extradition proceedings are criminal in nature and therefore fall under the DPP's Article 157 mandate. Okay. Under the Extradition Commonwealth Countries Act, a fugitive is not to be dealt with except in pursuance of the written authority of the DPP. So this is where we obtain the authority to proceed, pursuant to Section 7 of the Extradition on Commonwealth Countries Act. So, briefly, I feel appear to have lost. Okay, yes. So to continue, Supreme Court has held that extradition proceedings are criminal. The extradition proceedings are criminal in nature, and thus initiation and conduct of extradition proceedings, including issuance of the authority to proceed, is vested in the DPP and not the AG. The AG's role is limited to receiving and transmitting requests as part of the executive's international relation functions. In a few, my screen is misbehaving. So I beg for your indulgence. No, it is okay. So there is a Supreme Court decision on the same issue. The decision is known as the DPP versus Okemo 2022 decision. The Supreme Court, the majority, held that extradition proceedings in Kenya are criminal in nature, as evidenced by the language and structure of the Extradition Commonwealth Countries Act and the constitutional framework post-2010. The DPP and not the AG is constitutionally mandated to initiate and conduct criminal proceedings, including extradition by virtue of Article 157. The AG's role is limited to receiving and transmitting requests as part of the executive's international relations function. Section 7(1) of the Extradition Act, which refers to the AG, must be construed in conformity with the Constitution, meaning that the DPP is the competent authority to issue the authority to proceed. And the court rejected the argument that the inclusion of extradition in the ODPP's Act definition of prosecution was a drafting error, finding that the Parliament's intent was to vest such proceedings in the DPP, and the standard of proof in extradition is prima facie, not beyond a reasonable doubt, and the extradition hearings are not plenary trials of guilty or innocence. The authority to proceed issued by the DPP in July 2011 was therefore valid. So that is the decision that was testing the candidate to answer. So DPP versus Okemo and 4 others 2022 Supreme Court decision. So up to that point, I believe we have answered question 5 or 4 extensively. Let me now narrow down further to check whether there is another question that requires an interpretative and purposive we can talk on extradition proceedings if we actually do not know how the proceedings operate in Kenya. Okay. How do extradition proceedings operate in Kenya? Okay, so basically, in Kenya, extradition is a court-supervised surrender process that starts with a foreign request. This is through the executive. Then it moves to arrest and a magistrate committal hearing on extradition criminality threshold. Then it ends with an executive surrender warrant, subject to constitutional safeguards on bail, fair hearing, habeas corpus, and judicial review. So there are some statutory regimes that provide for this procedure. If you look at the Section 9 of the Extradition on Commonwealth Countries Act, it gives the DPP the power to or the authority to proceed and a committal hearing pursuant to the courts. Then there is another provision of the law called Extradition Contiguous and Foreign Countries Act, whereby if you read Section 13 of the same Act, it says that notwithstanding that a warrant for the arrest of any person issued in a country to which this part of this Act applies may not yet be endorsed in persons of this Act, a magistrate may issue a provisional warrant for the arrest of such person on such information and such circumstances as would, in his opinion, justify the issue of a warrant if the offence of which that person is accused is an offence punishable by the law of Kenya and had been committed within its jurisdiction. And such warrant may be endorsed in the manner provided in the Criminal Procedure Code and may be executed accordingly. When a person is arrested under such a provisional warrant, no order may be made under Section 14 for his return to the country in which the original warrant was issued unless the original warrant is produced and endorsed in accordance with this part, and he shall be discharged unless the original warrant is produced and endorsed within such time as the magistrate thinks reasonable. So generally, this provides for the provisional warrant and the requirement to produce and endorse the original warrant within the time stipulated. Then, Section 9 of the same Act talks on surrender of fugitive criminal. This is the act known as Extradition, Contiguous and Foreign Countries Act. Whenever a magistrate commits a fugitive criminal to prison under this part of the Act, he shall inform the criminal that he will not be surrendered until after the expiry of 15 days, and that he has a right to apply for the issue of directions in the nature of habeas corpus. Upon expiration of the period of 15 days, or if directions in the nature of habeas corpus are issued, after the decision of the court upon the return to the directions as the case may be, or after such further period as may be allowed in either case by the CS, the Cabinet Secretary may by warrant under his hand and order the fugitive criminal, if not set at liberty on the decision of the court, to be surrendered to such person as is, in his opinion, duly authorized to receive the fugitive criminal by the country from which the requisition for the surrender proceeded, and the fugitive criminal shall be surrendered accordingly. Any person to whom such warrant is directed, and the person so authorized as aforesaid, may receive, hold in custody, and convey into the jurisdiction of that country the criminal mentioned in the warrant. So those are the governing rules. What are the steps that a student ought to describe when it comes to answering what amounts to a full extradition proceeding? So step number one, we have the incoming request. So the requesting state sends an extradition request through the appropriate government channel, often via the AG or Foreign Affairs Department. The AG, being the executive channel, will receive the same and transmit the request internally. And the DPP evaluates whether the request can proceed under the applicable act, where we have Cap 76 or Cap 77, and constitutional constraints. If yes, the DPP issues or anchors the prosecutorial steps or the authority to proceed that has been conferred upon him. Then we have the arrest stage. So remember, the first stage is the incoming request, then the second stage is the arrest stage. Arrest may occur, 1, on a provisional warrant pending full papers, as you have seen in Section 13 of which Act? Of the Extradition, Contiguous and Foreign Countries Act, or on a warrant issued under the relevant extradition procedure. The arrested person must be produced before a court as soon as practicable, as we have seen in Section 9, within the stipulated time. Then after arrest, we have committal proceedings before the extradition magistrate. The DPP prosecutes the extradition application in the magistrate court per the Okemo decision that we recently read when it comes to the difference between the DPP and the AG when it comes to prosecution of extradition proceedings. Then the court conducts a committal hearing but not a full trial. Under Cap 77, the court applies a trial-like jurisdiction and powers and commits if the evidential threshold is met. If satisfied, the magistrate commits the fugitive to custody to await surrender. If not, the person is discharged. This is eminently directly captured in Section 9 of which Act? Extradition, Contiguous and Foreign Countries Act. Then you have the post-committal window. Under Cap 76, once committed, the person must be told they will not be surrendered until after 15 days, and then they may apply for directions in the nature of habeas corpus. Okay? After the waiting period and after habeas corpus is determined if filed, the CS may issue a warrant of surrender. Person to which section? Section 9 of the Extradition, Contiguous and Foreign Countries Act. So if you are keen, you are still navigating through Section 13 and Section 9 of the Extradition and Contiguous and Foreign Countries Act. Okay. So what you need to understand in this procedure is that bail is available in appropriate cases, but courts weigh flight risk and treaty obligations, and bail pending appeal is not always straightforward. And habeas corpus or judicial review or constitutional petition, they are used to challenge illegality, procedural unfairness, jurisdictional error or rights violation, but courts won't convert a judicial review into a merits rehearing. Okay, that was the key takeaway. So maybe to sum it up, you have the requesting stage, incoming request to the AG, sent to the DPP, there is an arrest, there is a provisional warrant, okay? There is arraignment of the arrested person as soon as practicable as possible, person Section 9. There is committal proceedings before extradition before a magistrate. This is where many students will omit to say. The DPP is the one to prosecute the same. There is a committal hearing, but not a full trial. If the evidential threshold is met, you will be committed. The fugitive will be committed to custody to await surrender. If not, the person is discharged. Post-committal stage, once committed, the person must be told, this is mandatory, that they will not be surrendered until 15 days, and that they may apply for directions in the nature of habeas corpus. And after the waiting period and after the habeas corpus is determined if it was filed, the CS may issue a warrant of surrender, and that marks the end of the extradition proceedings in Kenya. Okay, that is it. That is it. Now another question. Back to our JSC interviews. Question 502. How does the DPP ODPP ensure that witnesses or victims have not been intimidated or coerced before withdrawing a case? Okay. So the ODPP must not withdraw under Section 87A SCPC quietly, or on a bare claim that witnesses are unwilling. Before withdrawal, it should, and the trial court must, demand reasons on record, notify and hear the victim and complainant, and where intimidation is suspected, it triggers protective and investigative steps, where we have witness statements on voluntariness, the OB entries and risk assessments, and also witness protections, so that the court can be satisfied the decision is not driven by coercion. So withdrawal is not automatic. A public prosecutor may withdraw a case only with the consent of the court at any time before judgment. This is pursuant to Section 87A of the Criminal Procedure Code. Only with the consent of the court is when the DPP can withdraw a case. DPP's discretion is constitutionally constrained, because if you read Article 157(11) of the Constitution of Kenya, discontinuance must comply with the Constitution and be guided by public interest, interest of justice, and avoidance of abuse. Okay. Victim protection, victim participation. We have the Victim Protection Act, Section 42B of the same. Victims are entitled to be informed and have their views considered before decisions affecting them, including withdrawal. Okay. So these are the various aspects that the court or the law has put in place to have a checker, so that the previous prosecutorial powers to withdraw a case without consent, without compliance with the Constitution on public interest, interest of justice, and avoidance of abuse, without notifying the victims, pursuant to Section 42B of the Victim Protection Act, has phased out. Okay. So courts have repeatedly set aside withdrawals where the ODPP or trial court did not involve the victim and did not record sufficient reasons. Okay. That is it. Let us look for another question. How has the Supreme Court? This is question 500. Let me see it in a clearer angle. How has the Supreme Court interpreted the application of international law rules in Kenya under Article 2.5? Okay. So the Supreme Court treats Article 2.5 as a direct incorporation clause for general rules of international law, but only as part of Kenyan law subject to constitutional supremacy, and to prove that the asserted rule is in fact a general rule and not a mere soft law. Because Article 2.5 of the Constitution of Kenya directly provides that the general rules of international law shall form part of the laws of Kenya. Okay, so international law is part of Kenyan law, but not above the Constitution. Soft law is not automatically general rules of international law. The court distinguished binding international law, where we have customary law and treaties, from soft law, e.g. UN guidelines and general comments, holding that soft law is persuasive only unless it has crystallized into customary international law or is otherwise incorporated. That is the main distinguishing, the distinguishing factor that the Supreme Court had to lay before the public. So how now do you treat Article 2.5 correctly? You identify the norm you are invoking and classify it, whether it is customary international law or whether it is a general principle versus treaty versus a soft law. Then, if relying on customary international law, plead and prove indicia of custom or state practice and opinion juris, not just citations to UN guidelines. Then show compatibility with the Constitution, because Article 2 of the Constitution talks on supremacy and relevance to the issue that the Kenyan court is determining. Then use international law as an interpretive tool for constitutional and statutory provisions and for a direct rule only where it is truly a general rule of international law and not displaced by the Constitution of Kenya. That is how the Supreme Court has considered the issue of interpretation of international law pursuant to Article 2.5. Can the High Court? Question 496. Can the High Court? I believe it is clear from here. Can the High Court handle a presidential matter? What is your response to that? Can the High Court handle a presidential matter? And the answer is no, because it is directly interpreted in the Constitution of Kenya that the High Court cannot hear a presidential election petition challenging the election of the president. That jurisdiction is reserved to the Supreme Court under Article 140 and Article 163(3)(a) of the Constitution. The High Court may only handle presidential-related disputes outside that narrow Article 140 window. Each where we have the constitutional interpretation and enforcement, and IEBC nomination disputes via the proper mechanisms, but must down its tools if the substance is a presidential election challenge. Okay. Then let me scroll up so that you can see other questions. What provisions of the law? This is question number. What provisions of the law give the High Court the mandate to hear an application to stop election tallying? So this is the High Court's mandate to stop or interrupt tallying, if at all, comes from its constitutional jurisdiction to enforce the Constitution and supervise public bodies, but courts routinely hold they will not micromanage tallying where the Constitution and statute reserve election disputes to IEBC and to election petitions after declaration and gazettement. Okay. So Article 165(3)(b) of the Constitution of Kenya, the jurisdiction to determine whether a right or fundamental freedom has been denied, violated, and infringed. Then you have jurisdiction to hear constitutional interpretation questions. Then you have supervisory jurisdiction over subordinate courts and bodies or persons exercising judicial or quasi-judicial functions. Then you have Article 23(3), where we have power to grant appropriate relief, including conservatory orders, injunction-type relief in enforcement of the Bill of Rights. So Article 88(4) of the Constitution of Kenya provides that IEBC settles electoral disputes, including nomination disputes, excluding election petitions and disputes after declaration of results. Excluding election petitions and disputes after declaration of results. Okay. The High Court has repeatedly held it cannot assume election petition jurisdiction before gazettement and declaration of results, and that many pre-declaration challenges should go through IEBC mechanisms and then an election petition and not a judicial review or an injunction. Okay. That is the angle that the panel was expecting a student or a candidate to cite. Let us read the second question. For question 494. If the litigant has very valid reasons and evidence of ballot stuffing, will you still be reluctant to stop the process? The answer is yes. If you have had verifiable evidence of ballot stuffing, a court can intervene, but it will still be cautious about stopping tallying as a remedy. The most realistic urgent relief is preservation and custody orders or access orders or directions that secure the evidential trail, pending the proper election dispute forum. Courts avoid orders that paralyze the statutory or tally or declaration mandate unless the legality is clear, imminent, and no other remedy will protect the process. Remember the Section 39 on Elections Act that says that IEBC must determine, declare, and publish results immediately and must tally and verify results through the statutory architecture. So courts are reluctant to grant interlocutory relief that effectively stops or delays the statutory election timetable unless the applicant meets the strict preservation or necessity threshold. Where the threshold is met, superior courts have granted conservatory orders to preserve the subject matter, typically post-judgment and pending appeal in election disputes. So we have seen another situation where the High Court declined urgent conservatory orders aimed at restraining gazettement or swearing in and has emphasized the proper election petition route after gazettement, even where allegations are serious. This was seen in the case of Lenny Maxwell Kivuti versus IEBC, a decision on that was held in 2017. Then the other question before you, let us look at the difference. What is the difference between diversion and a plea bargaining? 491, question 491. What is the difference between diversion and a plea bargain? Diversion keeps the suspect, diversion keeps the suspect or accused out of or exits them from the criminal trial track through an uncustodial, rehabilitative, and restorative pathway, while plea bargaining keeps the matter in court and ends it by a negotiated guilty plea to agreed charges with an agreed factual basis and sentence position recorded by the court. So plea agreements are negotiated after charge and before judgment and can include reduction to a lesser offense or withdrawal and stay of other charges pursuant to Section 137A of the Criminal Procedure Code. Plea agreement is entered into by or with authority of the DPP and is recorded and accepted by the court after the accused is advised of rights and the court is satisfied there is a factual basis. This is pursuant to Section 137B and 137F of the CPC. Diversion, on the other hand, is primarily driven by the ODPP's diversion policy framework and is tied to restorative alternative justice principles often used for minor offenses or vulnerable offenders and exceptional cases. Okay, so courts distinguish diversion from plea bargaining in practice, in that diversion is not assumed for serious felonies and may be rejected even where parties reconcile. The court may point parties to plea bargaining instead. Because plea bargaining is a structured statutory progress, the DPP controls the acceptance and the court must be notified or satisfied on the voluntariness and factual basis. Okay, if you look at the differences now between the two when it comes to various heads of the same, you look at the stage. Diversion is ideally pre-charge or early post-charge to exit the criminal trial process. On the other hand, plea bargaining is only after charge and before judgment. Then you look at the outcome. Diversion typically leads to no conviction because the case is resolved through conditions where we have apology, compensation, counseling, community service, etc., depending on the problem. When plea bargaining ends with a conviction on a guilty plea to agreed charge or charges once the court accepts or records the agreement. Then if we look at the forum or control, where we have diversion. Diversion is an administrative or prosecutorial pathway. This may require court involvement if already in court, depending on the posture, and plea bargaining is a court-supervised statutory process, and the court must be satisfied on right, voluntariness, and factual basis pursuant to Section 137F. When the same are preferred, diversion is preferred for low-level offences, first offenders, juvenile or vulnerable persons, and restorative justice cases, while plea bargaining, where evidence supports guilt, but parties agree on reduced charges and or sentence position, including serious offences where diversion is inappropriate. In the other question, you can read question 484. Can you give us some examples of the rights provided for victims under the Victim Protection Act? So the Victim Protection Act gives victims concrete participation, protection, information and compensation related rights throughout the criminal process and related proceedings. So for example, we have the right to be treated with dignity and respect and to have their privacy protected. This is pursuant to Section 4 of the Victim Protection Act. Okay, right to be treated with dignity and respect. Then you have the right to be informed of key steps and decisions in the case, where we have bail, plea bargain, withdrawal, sentencing, and release, and to receive information in a language they understand. Then they have the right to participate in proceedings, to have their views considered where decisions affect them, including discontinuance, withdrawal, and plea bargaining and sentencing. Then the right to protection and safety, to request protective measures where there is intimidation, threats, or retaliation risks. Then the right to restitution and compensation, to seek reparation of where we have compensation from the offender and or through statutory schemes where applicable. Okay, so that is it. Right to be treated with dignity and respect, to have their privacy protected, right to be informed, right to participate in proceedings, right to protection and safety, right to compensation. Okay, I was reading through the questions. Read question 485. Do victims have any role to play in plea bargaining? And 486. Is the victim's role in plea bargaining merely for information, or is their consent sought? So, victims have a statutory right to be consulted and to make representations in plea bargaining, but their consent is not required. The DPP retains the final prosecutorial discretion, and the court controls fairness and sentencing. So, if you read Section 137D of the Criminal Procedure Code, victim consultation is mandatory before a plea agreement is concluded. Plea agreements may include compensation pursuant to Section 137. Sentencing must consider victim impact and agreed compensation. Section 137. Victim participation is relevant where plea bargain incorporates restorative terms pursuant to Section 15 of the Victim Protection Act. Okay, so consultation is not giving the right to veto. Even where the victim or family opposes the deal, the plea agreement can proceed if the DPP complied with consultation and the objections were heard and recorded, and the DPP therefore retains prosecutorial discretion. Victims must be involved in the plea bargaining process and victim impact statement considered. This is treated as mandatory. Victim participation does not create a second prosecutor. It is limited and managed to protect their accused fair rights and DPP's mandate. So, do victims have any role to play in plea bargainings? Yes, the victim or representative should be consulted before the plea agreement is entered. They can give their views and objections and can push for compensation, and their victim impact goes to sentencing. Is the victim's role merely for information, or is their consent sought? It is more than information. The law requires consultation and an opportunity to make representations pursuant to Section 137D. But it is not consent in the sense of a veto power. The DPP may still proceed subject to a legality or fairness and the court's acceptance of the same. Okay. Then I beg you to read question 479. Since 2010, has the place of judicial review changed in Kenya? And the answer is a complete yes. Okay. What is happening to my laptop? Okay, yes. Since 2010, judicial review in Kenya shifted from a narrow common law where we had Order 53 on Law Reform Act, control of administrative action, to a constitutionalized and statutory regime grounded in Article 47 and the Fair Administrative Action Act. My screen is misbehaving in a few. So there is a shift from the narrow common law Order 53 or Law Reform Act, where it is now grounded in Article 47 and the Fair Administrative Action Act, with broader remedies and increasingly proportionality, while still retaining the core focus on legality, rationality, and procedural fairness rather than merits. Okay, so it has now taken a core focus on legality, rationality, and procedural fairness rather than merits. Okay, so Fair Administrative Action Act pursuant to Section 7 provides for the ground, and Section 11 provides for the remedies. This codifies reviews grounds including proportionality, legitimate expectation, and unreasonableness, and expands relief beyond traditional prerogative orders. If you read at Article 47 of the Constitution of Kenya, constitutional right to lawful, reasonable, and procedurally fair administrative action, and written reasons where rights are adversely affected. Order 53 still exists. Okay, this is where we have the leave requirement, statutory mandamus and prohibition procedure, but it now operates alongside constitutional petitions and the Fair Administrative Actions Act, pursuant to Order 53, Rule 1 of the Civil Procedure Rules. So the High Court has repeatedly treated Article 47 plus the Fair Administrative Action Act as the modern anchor for judicial review and has granted JR a relief where administrative action is arbitrary, ultra-vires, or unfair under that framework. So courts continue to insist JR is primarily about process, not merits, unless the statutory or constitutional framework, e.g. proportionality, justifies a deeper interrogation. Okay. So what changed since 2010? From prerogative remedies to a right-based cause of action, because the JR is no longer only a discretionary common law control mechanism, it is enforced in Article 47 of the Constitution. Then you have broader grounds and remedial menu, where we have Fair Administration Action Act, Section 7 and 11 expressly adds and structures grounds including proportionality, unreasonableness, legitimate expectation, and remedies. Okay, where we have declarations, reasons, remittal, temporary relief, compensation in appropriate cases. Then you have multiple procedural pathways today. You can still proceed under Order 53 for mandamus, certiorari, and prohibition, but many litigants now bring constitutional petitions. Okay, sometimes with exhaustion questions under the Fair Administrative Action Act. So substance still constrained. Despite constitutionalization, courts generally avoid rehearing the merits. They police jurisdiction, legality, fairness, rationality, and where pleaded, proportionality. Okay, so that is the test now that we are falling under: proportionality, rationality, fairness, legality, and jurisdiction. Okay. Read question 477. In Kenya, could you take us through the procedure of how plea bargaining is conducted? In Kenya, plea bargaining is structured, court-supervised process under Part 4 of the Criminal Procedure Code. Parties notify court of intent to negotiate. Court does not negotiate. The DPP or authorized prosecutor and accused agree in writing. The victim is consulted. Court then conducts a plea inquiry, confirms voluntariness and competence and a factual basis, and either accepts conviction plus sentence or rejects or orders a fresh trial and negotiations are barred. Okay. So what are the steps that you have to follow? Number 1, confirm the matter is suitable for plea bargaining and the accused is already charged. Okay. The accused must have been already charged pursuant to Section 137A3 of the CPC. Then initiate the negotiations. Either the prosecutor or the accused or the advocate of the accused initiates the negotiation. Then you notify the trial court of intent to negotiate. Parties notify the court. Courts must not participate in the negotiations pursuant to Section 137C. Internal or DPP approvals ensure the prosecutor has DPP authority and approval where required pursuant to Section 137B. Okay. Consult the victim where applicable, because prosecution must consult as required under Section 137D of the CPC. Then reduce the plea agreement into writing, where you capture the charges to be pleaded, withdrawal or stays, and agreed facts, and any restitution and compensation terms. So you must reduce the same into writing. Then present the agreement in open court for recording, where the prosecutor tables the agreement, court conducts a plea inquiry, explains rights being waived, penalties, and confirms voluntariness and competence pursuant to Section 137F. Then factual basis is read and recorded. Prosecution lays the factual basis, and the court must be satisfied it supports the plea. Then the court makes its decision. It either accepts the agreement becomes binding, factual basis is part of the record, and the court convicts accordingly. Then if it rejects the reasons are recorded, the agreement is void, negotiations inadmissible later, plea of not guilty entered, trial process usually before another court unless waived, no further plea negotiation on same facts, pursuant to section 137J. Sentencing, the court hears parties on sentence and considers custody time and the victim impact statement, timing of plea, and compensation as agreed, pursuant to section 137. Okay. So briefly, confirm eligibility, check, initiate negotiations, notify the trial court, do internal DPP approval check, consult the victim, reduce the plea agreement into writing, present agreement in open court, factual basis is read and recorded, court makes the decision, it either accepts it, okay, it either rejects it, then you go sentencing. That is how a plea agreement, plea bargaining is conducted in Kenya. So read question 469 as read together with question 470. In a surrogacy case, with a biological parent and an intended legal parent who has the right of custody and the right to name the child, and what if there is an agreement between the biological parents and the intended legal parents regarding the child? So until a court order, typically an adoption order changes a legal parenthood, the biological parent and in practice, the birth and gestation mother is treated as the legal mother. They have legal custody and parental responsibility rights, including the right to determine the child's name and register the birth, and the intended legal parent only gets those rights after the lawful transfer, usually adoption. A private surrogacy agreement can guide conduct, but it cannot by itself transfer custody or parental responsibility. So if you read section 31 of the Children Act, parental responsibility includes, amongst other things, to determine the name of the child and procure birth registration. If you read section 32, parents have parental responsibility on an equal basis, no superior claim as between them. Then section 32, parental responsibility cannot be relinquished or assigned to another person, i.e. you can't contract it in any way. Pursuant to section 92, when custody is conferred by a custody order, applicants include a parent or guardian, and in limited cases, a non-parent with consent and actual custody or showing cause, pursuant to section 102. So surrogacy, a surrogate or birth mother is treated as the legal mother, pending a lawful transfer or adoption, issuing birth documents naming the commissioning, or intending mother as mother before that process was held unlawful. Because Kenya still lacks a comprehensive surrogacy statute, courts have routinely used adoption to regularize intended parenthood, including where intended parents are genetic parents, applying the best interest and principle and requiring proper consents and reports. Okay. So right to name the child sits with parental responsibility. So unless and until the intended parent becomes the legal parent, e.g. through adoption, they do not have the primary legal right to name and register the child. Even if there is an agreement between the biological children, and the agreement may be relevant evidence of intention and consent, but it does not in itself transfer parental responsibility and custody naming rights, because the parental responsibility cannot be relinquished or assigned by contract, pursuant to Children Act section 32(4). The correct legal route is to move the court, typically an adoption cause, to vest legal parenthood in the intended parents. Once an adoption order is made, parental rights and duties in custody and related incidents vest in the adopters, pursuant to Section 202 of the Children Act. So up to this point, I intend now to mark that to reflect the end of session 1, and we will return back to continue from where we have left. But there is a peculiar question that I can see before you. 467, you can't pass that question because it is invoking a situation where a person has been arrested in a separate jurisdiction where he lives. If an accused person is charged in Milimani but applies for relief in Machakos because they live there, how will you react as a judge? Okay? Or as an advocate. Okay? As an advocate is the one that is proper. I'd object. That is classic forum shopping. Residence alone does not let an accused person pick a different station. The case should ordinarily proceed where the offense was committed and where the accused was apprehended or is in custody or answered summons. If they want a different station, the proper route is a High Court transfer application under Section 81 of the CPC, proved on the statutory grounds, not I live in Machakos. Okay. If you read Section 71 of the CPC, local limits where offense committed or accused apprehended in custody. This is the ordinary place of trial. Where act done or consequence ensured, pursuant to Section 72, or change of venue, transfer is a High Court power on specific grounds, on fair trial concerns, unusual questions of law, convenience of parties and witnesses, etc. Not notice to DPP, affidavit in support, and possible security for costs. And courts may even reject transfer where the only complainant is the accused personal inconvenience, venue is tied to where the offense occurred and where witness or documents are. Okay. That is it. So at this point, I mark that being the end of oral marathon session 1. Thank you for your